Over the centuries, as cities and towns in England began to grow in size and complexity, it became obvious that there should be laws to regulate the quality and characteristics of buildings and similar structures in those towns and cities. The Metropolis Local Management Act gave this power to a local board of works. The way it worked was that anyone erecting a new building must provide notice to the board at least 7 days before beginning work, and if they did not, the Board of Works could pull down the building at the owner's expense. Cooper had hired a builder to erect a new building, and there was a dispute as to whether he had given the right notice and whether he had given it in time. Without any notice to him, though, the Wandsworth Board of Works sent workers in the middle of the night, to pull down the partially completed building. Cooper was unamused and sued. There was no doubt that the board had the power to do what it did. The question was whether they used that power properly. Cooper claimed that he should have had notice and an opportunity to respond to their intention. The board pointed out that the Act itself gave him no such right. The court used this as an opportunity to clearly enunciate the importance of the hearing rule of natural justice. Chief Justice Earle said the house in question was built only to a certain extent, but the power claimed would apply to a complete house. It would apply to a house of any value and completed to any extent. And the limitation which we are going to put upon it is one which ought, according to the decided cases, to be put upon it, and one which is required by a due consideration for the public interest. I think the board ought to have given notice to the plaintiff and to have allowed him to be heard. Justice Willies put it this way: a tribunal which is by law invested with power to affect the property of one of Her Majesty's subjects is bound to give such subject an opportunity of being heard before it proceeds. That rule is of universal application and founded upon the plainest principles of justice. So the entitlement to natural justice is automatic and doesn't require specific words in the statute.